There we are. So good morning. This is the Legislative Committee on Judicial Rules on Wednesday, June 16th, 2021. We have a number of rules that we're going to be taking a look at, and we'll get right started so we can all try to enjoy some of this beautiful day that we're having here in Vermont. So we will turn it over to Judge Morris to start out with the Rule 6B and Rules 4C and 10 of the Vermont Rules governing qualifications, list, selection, and summoning of all jurors. Good morning.
Okay. Thank you, Mr. Chairman. And in this phase, I'm speaking on behalf of the Committee on Public Access to Court Records. As you'll remember from December, this package of rules was intended to address some inconsistencies in the juror qualification rules and in the procedural rules for civil and criminal procedure regarding jury selection. It also added an exception to the public access rules, which generally provides that the written answers that potential jurors give to questionnaires sent out in advance to them, including a lot of personal family data, whether there are health issues that would preclude them from serving and the like, sensitive information, is generally not publicly accessible unless upon a finding of good cause by the judge. The main exception here, of course, is access by the parties and their lawyers in any given criminal case, or in any given case. As a basic due process principle, those folks in the case have an absolute right to access to the information in issue. There's one exception from that, and that is where a juror submits in advance of the jury selection day health information, generally in the form of a letter from a healthcare professional, going to their mental or physical capacity to serve. This is generally patient privilege information, and if a juror is excused by the court before even showing up for jury selection, then the parties and lawyers do not have a right to see that information unless there's a particular challenge to the way in which the whole jury panel was initially summoned, or an issue as to racial disparity or gender disparity in the composition of the entire panel. There, a judge could order everything to be revealed. So that's the basics of this. And we cured the inconsistency between the jury selection rules, which are within the province of the court administrator, and the rules regarding civil and criminal procedure. This set of rules was promulgated effective yesterday. And so we don't have a lot of experience with dealing with the operation of this rule. I guess I want to make 2 points about this rule that, as it's been promulgated, is one of the issues unresolved is whether the lawyers and parties can receive electronic copies of juror questionnaires. And the answer to that, as I believe I mentioned in December, is that the juror server, which houses the scanned versions of juror questionnaires, doesn't speak at all to the Odyssey system, case record system. And there are also privacy issues associated with it. In addition, at this time, the court is moving to a new jury management system, electronic jury management system, that is sponsored by the Tyler Technologies that also runs Odyssey. The target date for that is September. So you'll see in the package that the reporter's note of the promulgated rule on page 5 has an extensive discussion of the dynamics of that issue and why at this juncture electronic versions of questionnaires are not distributed, contemplating that things might change later. The only other thing I want to say about the rule that's promulgated is that Chair Lalonde asked me a question about what other jurisdictions do in treatment of confidentiality of juror questionnaire content, and whether other jurisdictions have what might be considered a presumption against public access versus a presumption for it. And I actually dug into this some, and it's kind of a frustrating search because not all the jurisdictions have either a statute or a court rule or even a court decision yet about this issue. I think it just hasn't risen up there. But I did find that there's 39 jurisdictions that have some rules or court decisions at all about confidentiality or total public access. And by my count, there were 29 jurisdictions that treat juror questionnaires as confidential, as we do and as we would do under the promulgated rule. All of the jurisdictions in criminal cases must observe the decision in Press Enterprise. There are two decisions regarding criminal cases and press access, therefore public access, to completed juror questionnaires in criminal cases. You will all have in mind the Sixth Amendment guarantee of a public trial, and therefore following from that, in addition to common law rights of access, the court has to engage in a balancing test of the public interest in disclosure of the information in issue versus damage to privacy interests, and make a decision about what juror content information can be revealed or not. The court has the ability to redact, in other words, take names off of and addresses off of the questionnaires, so that what the jurors have said can be generally accessed without identifying a particular person. The most recent, I think, noted case regarding this was the Derek Chauvin prosecution in Minnesota for murder, the police officer who was charged and convicted there. The judge in that case, under the Minnesota rule, which allows jurors to actually, as they fill out the questionnaire, object to completion and not answer the question before showing up in court. The judge there gave jurors, identified them by number, redacted the content of their answers from their identities so that they couldn't be matched up for obvious security and privacy interests. And he said that in that case, he'd reconsider the names being revealed 60 days after resolution of the case. And to my knowledge, there hasn't been any decision. To come back to our experience, I think in a case of great notoriety, a purely anonymous jury would be an absolute outlier where there had perhaps been known threats to the process. However, I think a court could, in a case of great notoriety, to address privacy and a defendant's interest in a fair trial, redact questionnaire content. You'll also see, if you read closely, there have been a couple of modifications of the reporter's notes. Essentially, one that's been made is a really good one. I reference voir dire throughout the draft and notes. Basically, the comment was, why don't you just say jury selection? Nobody knows what voir dire is. So that change has been made, but there are some others that discuss further the operation of the rule.
I appreciate it. So are there any questions? Senator Sears.
Yeah, Judge, I'm reading on page 3.
Okay.
Where absent of finding a good cause for disclosure by the court. And I certainly understand the need for confidentiality of jurors, and particularly in our small towns in Vermont. But what would be good cause to go beyond the name and town of residence?
Yep.
I mean, everybody, once you release the name, everybody knows who it is. And most,
Right.
Not everybody, but most people will know who it is in Bennington or Montpelier or wherever.
Yeah, they would put 2 and 2 together. I think the answer there is partially found, Senator Sears, in page 2 in the reporter's note there, and also in the middle of the page, further describing what good cause would be. Where someone wanted to make a challenge to the array, which is obvious, or in the conduct of scholarly research or news accounts as to a contemporary jury composition and selection procedures. In such cases, the court may authorize disclosure with redaction or accompany with a protective order to prevent correlation of identity. So I think that's, generally speaking, the focus of what would likely be the request. Could somebody from town walk in and say, hey, I want to see Joe's questionnaire? Well, the issue would be presented as to, first of all, whether Joe had a right to object, but also not as a citizen asking for government, you're not entitled to this information, you need to show it. I think if a court had particular concern, they would perhaps notice the juror and provide an opportunity to be heard about what information could be divulged.
Thank you.
Yeah.
I mean, I want to let you know, I'm very concerned about this issue.
Right.
Given what's going on in other states and other locations, I mean, including threats to judges are not uncommon. 60 Minutes did a story the other night about a judge who, her son was murdered and her husband was
Oh, yeah.
seriously wounded by a complainant. I mean, people are, so, you do want to keep some things private.
Yeah.
And I don't want to sound like, I'm against the press and knowing everything they need to know. But on the other hand, at least until the deliberations are over, it's important to keep protecting our juries.
Yeah, I was going to say a real competing interest there is also I'll call it the health of our jury system. It's hard enough to get folks to show up in response to summons. And when they come in, generally speaking, they're terrified about what's going to happen. Is my whole life going to be laid out on the table in front of 50 other people? So that's understandable. We do our best to respond to that and honor their service. But data mining is another concern underlying this, is in terms of the personal data demographics that can be tracked to individuals. If it goes electronic at some point in the future, that will become a real concern. But you're right, we must always balance out those interests. And the other interest there is public belief in the integrity of our systems. Was this case thrown? And, in these days where truth is something we might not have unanimity about in the justice system, it's the same thing. Thank you.
Thank you. Thank you. I certainly.
You just were muted, Senator Sears, your last few words.
I say I support the rule. Obviously, it's already been promulgated, but I support the rule, but I just wanted to let you know that concern that I think all of us have.
Yeah.
Yeah, Senator Clarkson.
I would echo Dick's comments because, we are trying to balance things, but increasingly with the ability to find people online, threaten them, it just so hampers and really constrains people's willingness to serve. And I agree with Judge Morris also. I think this is a tough one. And I guess I apologize, I missed it. The disclosure would be of the name and the town, because the town means that you instantly know who they are.
Right. Yeah, I think what it speaks to is the fact that unless you're going to declare an anonymous jury, which you could do in a case on specific findings of imminent harm and action and threats that are documented, you could impanel a jury that is identified by number only and not by name and address.
Right.
So a motion would likely be made.
And that's up to the judge?
Yes. Yeah. Again, in balancing the interests out, much would depend on the position of the defendant, of course, entitled to the fair trial under the Sixth Amendment. But if the defendant were to join themselves in that request to assure a fair trial, I think that the judge would honor that, as well as the state position about, we got to keep the integrity of this case and extraordinary circumstances are presented. But we also do not want anonymous juries to become a regular feature of our system of justice either. So, it's an acid test balance of rights. Yeah.
So may I ask a procedural question?
Yeah, please.
If this rule is already in act as of yesterday or today, is already enacted, why are we bothering talking about it today? I mean, I'm very interested in this rule, just as Dick is, but I think we all are. But I hate to ask, why are we, if it's already been acted on, why are we spending time on it? I mean, other than the fact that it's important.
So I mean, we did have questions back in December, and there's a
Yeah.
couple
Right.
others that we're still going to look to have answered. But perhaps Eric could jump on and tell us just generally what we're looking at as far as promulgated rules and those that are proposed, and what actions really are in our purview. So Eric, please.
Yes, sure. Happy to. Eric Fitzpatrick with the Office of Legislative Counsel to follow up on Senator Clarkson's question and Representative Lalonde's background as well. So generally speaking, the rules come over to the Legislative Committee on Judicial Rules in one of three postures. The one posture might be that the rule has only been proposed, so it has not been promulgated yet. It's been proposed by the court out to members of the bar for comment. And in that posture, the rule, there's no requirement under statute or rule that those rules be sent to the committee for review. But historically, that's been what has been done, because it allows the committee to review the rules while they're still in the comment stage and make comments back to the court so that the court can incorporate those comments or choose not to incorporate them. But either way, they can at least be made aware of them, and then make a decision about whether or not the promulgated versions of the rules will reflect any comments that this committee made. So that's one possible posture. Another is that they've been promulgated. After rules are promulgated, there's a 60-day period before they go into effect. If they come over during that 60-day period, the way the statute is written, the committee can formally object. And if you formally object, according to the statute, the rule does not go into effect until it's a very old and interestingly worded statute. I've never known this to actually happen. But the way the statute is written is that the rule does not go into effect until the Chief Justice comes over to the legislature and reports on the rule, at which point it can then go into effect, although the legislature can always change it later on. There's some, as I say, it's never happened, so there's never been an opportunity to litigate the constitutionality of that procedure. Who knows? It's an interesting, unique procedure, but that's what's laid out in statute if it comes over during that window. The juror rules that we're looking at now come over in posture number 3, as you just mentioned, Senator Clarkson, which is that they've been promulgated. That 60-day window is expired, as Judge Morris noted, yesterday or the day before, so that they are already in effect. However, according to the statute as well, I think it's I'll pull that up where I think it's 12 VSA section 3A, something like that, or 1A. Under the statute, the committee can still object to a rule once it has any rule that's already in effect can still be objected. Now, it doesn't have the same effect. As I mentioned, if it's still in that 60-day window, the objection means that the rule doesn't go into effect. That's not the case if the rule is already in effect. The committee can object, the rule still remains in effect, but the committee the legislature, the statute specifically provides, and the legislature could do this anyway, I think, whether the statute expressly provided or not. But the legislature, as it frequently does, can amend court rules via statute. Now, you could pass a statute that says Vermont Rule of Criminal Procedure 6A is amended as follows. Now, of course, there is still the overarching separation of powers question there. Some rules might involve something that might be an inherently judicial function. Other rules may not. I don't think anybody could speak generally and say that the legislature amending a rule of court procedure is a separation of powers problem. It isn't necessarily. It all depends what the underlying content of the rule is. But procedurally speaking, that's something that you can do. So that's even if the objection at this stage doesn't prevent the rule from going into effect, it nevertheless is a formal notation of the committee's view on it, and then someone could introduce legislation next year to go ahead and amend that rule if you felt like that was the right policy move. So does that explain why you would still look at the rule even though it's already been in effect?
Thank you, Eric.
From the judicial side, I would just say we don't encourage that, of course, but in my memory, you've done it twice. The last time was Rule 3 and the after hours arrest and warrant requests. And then way back, Rule 15 depositions, simply passed legislation that laid out what the procedure would be. it's a rare thing, but I agree with Eric.
Appreciate that. Thank you, Eric. And Senator Benning.
Judge, last time we were talking about this rule, we had some discussion about pro se litigants and what access they would be entitled to. And I'm not sure whether you had any opportunity to follow up on that question. You sort of took it under advisement.
Yeah, okay. The text of the rule speaks to, in terms of access to parties and their lawyers. It doesn't mean conjunctively those who only have lawyers. But throughout the country, and I'm not sure we have recorded decisions on this, if a self-representative wanted access to this information, at least under our amended rule that we're just talking about, the court could issue protective orders that say, okay, here's how I see reasonable access to be accorded. And a lot would depend upon the circumstance of the interactions and presentation of the self-representative in court. As you all might, I guess, appreciate whether we agree, if a self-representative has been essentially obstructive, disregarding the procedures that anyone representing themselves must observe, the court could, based upon findings relating to that conduct in the case, remember jury selection is going to be at the tail end of the self-representative's work in the case, the court could find that there's a reason or basis for access to the questionnaires at the clerk's office or some other means of access, guaranteeing, though, that there is that opportunity for access. I mean, I think it's a major error, a reversible error, if a court were to preclude a self-representative from access to the same questionnaires that the prosecution has. But I think it would depend upon the conduct of the self-representative. A court could, in a given case, based on the conduct of a self-representative, say, we'll provide a written copy on your representation to the court, that no copy will be made as anyone else, and that you'll return the copy at the end of the proceeding. Case by case, basically. No fixed rule, but the rule does not preclude or restrict access only to lawyers.
Is there an instruction given to pro se litigants about the need to understand the rules ahead of time?
Oh yeah, there are numerous conversations. In my experience, I want to talk to somebody electing to represent themselves, even though respecting the right to do that, about the pitfalls and also the obligations that go with self-representation. And, you know, it could be words passed into the ozone, or it could be meaningfully received by the defendant, but that has to occur. I don't think any judge in our jurisdiction would fail to provide those obligation warnings. Not warnings as such as, you know, you're representing yourself, you have the right to, and we acknowledge and honor that. But as you're doing that, you see the lawyers have their obligations. We expect you will observe the same procedures.
Okay, appreciate that. I'm just curious about the normal standard practices. I walk up to the clerk's window and I say, can I have the jury questionnaires? I take them off into a side room and I review them. If a pro se litigant were to do that, I'm not sure that they would understand there are limitations about pulling out your cell phone and taking pictures of what you're looking at.
Yeah.
So that was my main thought. I just didn't know how far the discussion went in this potential breach of the rule.
I think the conclusion, while there probably was not a great deal of that discussion of that particular dynamic, the conclusion is that it's all dependent on the circumstances, and a overarching concern is that a self-representative not be disparately treated from lawyers, nor lawyers be more favorably treated. But as you know, we have Rule 11 obligation as lawyers and licensure obligations that can provide a very swift and severe reaction if there's a violation. Self-representatives don't. We only have contempt.
All right, thank you.
I just wanted to add to that. I wasn't going to mention this, but a while back there was a case in the Bennington District Court of a charge, and the pro se litigant disclosed information about a witness that resulted in information about that witness's criminal record in Illinois. I just think that is something that needs to be, it may not be part of this, But if that can happen with a pro se litigant with a witness list, I think that information they need to be treated the same as a lawyer in terms of consequences. And I don't know what they'd be, but that puts a lot of strain on the court system, quite frankly, and nothing happened to this individual. And I think that nothing happened to him for disclosing that information. So just as a caution that what is deemed to be information that a lawyer wouldn't be able to provide in a pro se case.
Yeah, I think the judges would be very much aware of that, and it depends on the advocacy relationship that is shown
Well,
and demonstrated by that.
there were no consequences to the individual.
Yeah. Contempt's a hard one. It's a hard hammer that judges are reluctant to use, because once you do it, there you go.
So I do know that there was one other issue that was brought up last December related to the scope of who could access the documents, whether there could be duplicates as far as investigators, other attorneys. And it's my understanding that I believe you already mentioned the protective orders that could be put in place, but also in the comment at the bottom of page 5 is where at least I thought I identified where that is addressed. And it makes it clear that authorized associates can have access to those documents. I don't know if you had anything more to add to that, but that looked to me like that resolved the issues that we had brought up.
Yes, it has. Back in December, we noted that this comment came in, but wasn't because of the timing of it before the committee. It seemed clear at that time, and the reviewing committees since, Public Access, Civil Rules, and Criminal Rules, all agree this is really a straightforward issue. Yes, if there's an investigator hired, members of the firm pool the questionnaires to all have access to them during selection. That's all appropriate.
I
Yes.
appreciate that. Any other questions? Otherwise, we can move on because we're only 20 minutes behind on the agenda. That doesn't bode well for my first full meeting as a chair of this. I apologize, but thank you very much, Judge Morris.
Thank you.
So I'm not sure, I'm looking on who all's here. Who is reporting on behalf of the Advisory Committee on Family Rules? Emily must be, since you just showed up on the screen. So we'll turn it over to Emily Weatherill for the rule VRFP 2A2 and 4.0B2.
Hi, good morning, everybody. Emily Weatherill, I'm the Deputy Clerk of the Supreme Court. I was wondering the same thing, Representative Lalonde, who was going to be reporting on this. I don't see Judge Kanan or Judge Davenport, who's the reporter for that committee. I'm happy to, this is a pretty minor promulgation. It's basically just changing some cross-references in the family rule to comply with some recent amendments to the civil rule. So I don't, I'm happy to.
Yeah,
Go ahead.
it's straightforward. And I guess what I'll do is just ask if there were any questions on this particular rule, because it really was very straightforward. Any questions from everybody else, or we might be able to gain a few minutes on our, I see Alan.
Imagine that we could move forward more quickly than expected.
I don't see any questions, so I think we're good with that one.
All right, good.
I appreciate that. So we're moving on to, and I don't see Judge Zone, or I guess.
I think Judge Morris probably is going to do the.
Judge Morris is
rules.
back. All right, for
Okay.
our rule.
Rule 11A3 and 7.
Yes, thank you.
I'm going to keep with the theme of the team, which is to keep moving if we can. The 11A3 amendment, we discussed this in December, follows from direction and an opinion of the Supreme Court in Re Benoit. This dealt with defendant's ability to enter into an agreement with the state with approval of the court to preserve a post-conviction challenge to what we call a predicate offense while still pleading to the enhanced offense. Classic example, DUI third. The state has to prove DUI first and second as well, and namely that that's a third. So a defendant under the Rule 11A3 procedure, which contemplates a plea agreement essentially, or at least agreement to preserve this issue, says, I'm pleading guilty or no contest to the DUI 3, but I want everybody to know I want to have preserved a right to go to the Superior Court Civil Division to do a post-conviction relief challenge to conviction number 2, because the judge didn't do a proper plea colloquy with me, or some other fundamental error in the entry of that plea, conviction, and sentence. So that is the procedure the court contemplated, and the court did, as we've seen, promulgate that rule. In December, the Chair Lalonde and Senator Benning both inquired, well, wait a minute here, why can't we have some alternative at least that allows a defendant to do the same thing without requiring the state's attorney to be on board with the preservation of that claim? And so then I indicated Judge Zone had proposed yet another amendment, 11A4, that would allow just that. And that language basically says that essentially there's no agreement contemplated, and you have not seen this yet, but I just want to point out that in response to the 2-member concerns, the Criminal Rules Committee has drafted and will shortly transmit to the court for publication. So you're going to see this yet again, that alternative where with the approval of the court, a defendant may preserve a post-conviction challenge to a predicate when entering a plea of guilty or no contest where there is no plea agreement by stating on the record at the change of plea what conviction they're challenging and the basis for it. So it still requires approval of the court. You'll see this again, but it does address the concerns presented by members as to, well, wait a minute, what about no agreement situation? So it was brought back to the Criminal Rules Committee following December 8th. There was some discussion and suggestion by Chair Lalonde about, well, could you establish some criteria here, such as where the state's attorney is rejecting a diversion referral or a deferred sentence? So the committee considered those options. Could we add criteria? And they decided, no, it would be up to the judge to just have a full colloquy with the defendant about that entry of that plea. So that alternative that you suggested is going to go to the court for publication.
Appreciate it. Thank you. Any other questions on this particular rule?
No, but I would like to just say thanks, Walt, because I think that's a major step forward.
Well, we'll see. You know, the promulgation's up to the court, and we will be receiving comments. But you know, it already was on our screen, and it responds to concerns that members of this committee raised. Yeah.
So not seeing any other questions on that, and getting very close to being back on time, I believe. That does cover everything that you needed to cover on that. I'm just double checking. Were you also reporting on the Rule 7, the indictment and information?
Yes. Yeah.
Okay, all right. Yeah, go ahead. I'm sorry. I
So
almost jumped over that one. I apologize.
no, and I'll be as quick as we can there too. From the promulgation of the body of the criminal rules in 1973, it has always been the rule that once a trial has started, the judge has control over whether the state can amend a pending charge to a higher offense or a different offense or add counts to it. And the test there is, would this amendment that sought delay the proceeding or cause substantial prejudice to the rights of a defendant? And you know, the common argument against this is surprise. Our theory's been set for the jury. Now you're telling us we're going to have to face a felony charge. We want to do additional discovery and the like. So that's during trial. It's always been the authority. Pre-trial, we've never had any restriction. And there are two competing interests here. One is the executive authority of the prosecuting attorney to bring charges and have them be at least recognized by the state for treatment under the law, and the prejudice that might lie not only to the defendant in terms of surprise or disrupting fair strategy, or to the court's docket. And so it does happen on the eve of a jury selection with a case that's been long prepared, sexual assault case or serious personal injury case or even murder prosecution. there are amendments to the charging documents given by the state. Sometimes these are the product of justifiable excuse, recent revelation of evidence. Sometimes they are to reduce a charge, although that's rare in comparison to increasing a charge, say misdemeanor to a felony. But when that happens on the eve of a jury selection, or even between selection and commencement of the trial, that causes a major disruption to the system. So the request for this was brought by Judge Robert Bent from the Orleans unit. And it is an issue that's faced by both judges and attorneys, late stage amendments. So the amendment that you see, which is has been published and comment period closed on June 8th, says that the state may amend charges prior to trial, but on the motion of the defendant, the court may in its discretion strike an amendment if the case would be unduly delayed or substantial rights affected. And it also, the amendment clarifies that if there is a change, this comes from our case law. If a court permits amendment, you can't omit the requirement of arraignment on the charge under Rules 5 and 10. So that specifies that. We received no comments except for one. One is that you should not refer to indictment in terms of information by the state, because the state's attorney, the prosecutor, doesn't indict. A grand jury indicts in a true bill of indictment. And so this rule will be amended as you see it to only refer to amendment of informations. It would require a prosecutor to go back and convene a grand jury to reconsider, and that's not likely to occur in the late stage of a case. So,
Thank you.
Yep.
That makes sense. Any questions? I don't see any hands, so we will move on. Thank you very much.
thank you.
So I believe we have Kinvin Roth up to bat next here on behalf of the Committee on Probate Rules.
Yes, thanks. Judge Kilgore had a hearing that ended up scheduled at 10:30. And I don't believe he's going to be able to drop in, but we have only one promulgated provision to refer to, and I will try to outline it briefly and answer any questions that you may have if I can figure out how to get it onto my own screen. Yes. This was a response by the probate and civil rules committees to legislation added in 2018, providing that the probate court on its own or on the motion of a party could refer a matter directly to the civil division for the purpose, and this was a key statutory piece, for the purpose of conserving judicial resources. The probate division shall consult with and obtain the consent of the civil division before making a transfer. Civil division's decision whether to consent is final and not appealable. That was enacted then as chapter 4, that is Title 14, Section 118. The probate oh, well, I have the wrong one showing here. Wait a minute. The probate rule adopted and as your agenda shows, promulgated on April 5th of this year and effective last week, does really two things. It takes a narrower view of the scope of the type of proceedings in which referral could be sought, this being in effect dependent on the initiative to seek referral within the probate court. And so limits the use of the proceeding to will construction proceedings under Chapter 3 of Title 14. That is then set forth in subdivision A of the rule. At any time after the petition in the probate court has been filed, the court, on motion of an interested person or the court's own motion, may undertake the referral process. Then the referral process in subdivision B of the rule is filled out with detail, not specifically outlined in the statute. The court is to send to the superior judge in the corresponding civil division unit request for consent for the transfer with a brief statement of the manner in which the transfer will meet the statutory test, conserve judicial resources. Superior judge is to respond within 21 days, either granting or denying consent. If consent is granted, then the matter is immediately transferred and the statutory provision is carried through here. The superior civil division superior judge decision is final and unappealable. So that's the way in which the Probate Rules Committee and then the court in promulgating the rule has sought to implement that statutory grant. As far as the Civil Rules Committee goes, that committee's interest in supplementing this rule in any way or in commenting on it was solicited Probate Rules Committee, and the answer was do what you want to do, in effect. So this rule then was proposed, sent out for comment, and promulgated through the agency of the Probate Rules Committee rather than the Civil Rules Committee. I'm glad to answer any questions or respond to any comments to the extent I can.
Yeah, and I also see that Judge Kilgore has joined us. If you have any additional comments on this rule, Judge?
I don't have any additional comments. Thank you.
Any questions? I'm not seeing any questions. So I did have one, I guess it's a very broad question. I know that this is it's fairly narrow as required under the act that was passed. Is this something that possibly down the road could be expanded to other kinds of considerations beyond the will construction, or was that really the one area that made sense, or is this kind of more of a pilot for doing this kind of thing? I'm just curious for down the road if we're going to see something in the legislature to look at this kind of procedure for other probate matters. And I'll either Kinvin or Judge Kilgore, although Kinvin, you look frozen. I'm not sure if you're still there or not. So I'll jump to Judge Kilgore.
Right. I'll do my best to answer the question. I believe the rationale of the Probate Rules Committee was that because this was the last section in revised Chapter 3, it made sense for this particular rule of referral to apply only to will contests. When you have a will contest, if it's necessary, well, if you have a will contest, it may be appropriate to transfer it, because that's, as I think everyone knows, the commencement of the probate process. And it seems to make some considerable amount of sense that if it looks like parties would prefer to have a jury trial on this particular issue, that the matter get resolved as soon as possible by transfer, rather than waiting for the probate court to make a decision and have that decision appealed to the civil division to then have a jury trial. I don't think the Probate Rules Committee was contemplating applying this rule to other portions of the probate statute.
All right, I appreciate that. Thank you.
Sure.
Any other questions? I'm not seeing any hands, so we will move on. I thank you very much for jumping on, Judge Kilgore, and rescuing Kinvin, who apparently dropped off because of bad connectivity.
All right. Thank you very much.
Thank you.
Good day, folks.
So moving on to Alan Keyes, who I see is here on behalf of the Committee on Civil Rules to look at a couple different rules that we have. So I'll turn it over to Alan. Thank you.
Good morning. The first two were, whoops, they just disappeared from my screen. The first two are technical in nature, in that one involves a rule change that changed the numbering of Rule 55. I think that's second on your agenda. And we later discovered that a specific subdivision of Rule 55 was referred to in Rule 80.1. So that rule change just updates the cross-reference to the correct reference. And the first one on your agenda is one you've considered before. We had a rule in the back of the book on the amount of a fee for getting a videotape recording. There was legislation that changed the amount of the fee that was brought to our attention. And so we amended the rule to state the current fee.
Seems fairly straightforward.
Yeah.
And so any questions on those two rules? And I'm not seeing any questions. And that means we are moving on. Let me see where we are, keeping track here. So that covered, did you cover rules? Are you covering Rule 7, pleadings allowed motions, or is that?
Yeah, that's has a little more substance to it.
Okay, yeah, all right, let's move on to that one then. Yeah.
This rule started with one of our members is a representative of the Bar Association, and suggested that it would be worthwhile to change the response time from 14 days to 30 days for all dispositive motions, not just summary judgment. And so we started out there, and then it took some twists and turns. What my memory may be wrong about it, but we ended up realizing we had two rules, Rule 7 and 78, that govern motion practice. And we ultimately decided we could consolidate them into the procedure for motions into one rule with that new 30-day provision. What you have on your agenda is the rule as it was sent out for comment. The comments expired in March. We received 5 comments, one of which is a good one. It says you're doing a great job. And the other 4 picked up on some items that we did change before we did recommend it to the court. The rule is now in late May been sent to the court as a recommended rule. One of the comments said, and I guess both first 2 comments relate to language we didn't change, that we just intended to make this 30-day change and incorporated prior language from one of the other rule. it said, at the very end of it said, if a motion was frivolous, the court could award terms. And one commenter said, that doesn't mean much to people who are just freshly out of law school. Can't you refer to sanctions or attorney's fees or whatever it means? And so we did change the word terms and costs to fees and costs in our recommended rule. The other provision that was changed had to do with when a request for evidence, an evidentiary hearing must be made by the opposing party. And the existing rule said the request should be made when the memo in opposition is made or the reply. Two people wrote in and said the reply is made by the moving party. This is confusing. Are you really saying you want the moving party to request evidence as late as the reply? And we changed that language from the proposed rule that you have to just say the request for evidence comes in with the opposing memo. The more substantive comment we had was, why don't you make a provision for surreplies? We had a little discussion in the committee and a little debate about it, but ended up recommending some language to the court that would regularize when still a fourth memo can be filed and stating some criteria. And there's the reporter's notes that accompany that. So I have that language if you want to hear it, if I can find it. It says the court may also allow a surreply memorandum if the memorandum would assist in clarifying the issues, particularly where the party seeking to file the memorandum is addressing newly raised factual or legal arguments by the opposing party. There may have been, but they would be more drafting issues, other changes made in the draft that we recommended, but those were 3 changes made in response to the comments we received.
And those changes are not reflected in this particular proposal we're looking at. So we'll probably see this next time. Is that what I'm to understand?
Yeah, well, if the court agrees with the changes, you'll see it as a promulgated rule.
Right. Okay. All right. Appreciate that. Are there questions on this rule? I don't see any. I particularly like the last line about even the ghosts of terms that it sought to abolish. I just want to compliment whoever got to write something a little more colorful in the commentary. So I appreciate that. So thank you very much, Alan, and I will move on. And I think we're even now 6 minutes ahead of time. I'll take credit for that, just as I'll take blame for having fallen 20 minutes behind earlier. So we're to Justice Dooley. And on behalf of the Vermont Supreme Court rules changes to address moving to electronic filing and other items. Welcome, Justice Dooley.
Thank you. I am the chair of the Electronic Filing Rules Committee, and that's the hat I'm wearing today. This is the second time I have appeared for this committee. This committee, of course, its primary responsibility has been creating proposed rules to implement the new electronic filing system, the Odyssey software, and particularly the electronic filing and service part of it to do. So we came to you last year with proposed rules. At that time, I think you reviewed them as these are being reviewed, that is, in the time in which they were proposed rules for electronic filing in the trial courts. You may recall that the system was rolled out in 3 times, starting essentially south to north in the state, and that 3 different rollouts ended up encompassing all of the state now, and so the trial court rules are fully implemented and fully in effect. There have been 1 amendment to them, and although they're not on the agenda today, Judge Morris, who you already observed wears many hats, will talk a little bit about those. But we're next. The system is ready to move on to the Supreme Court, which is the last of the main judicial functions of the Vermont judiciary. When we first did the rules, because of the time constraints of them, and because of questions about how it would operate with respect to the Supreme Court, we did not try to do coverage of the Supreme Court at all. Again, this would be a fourth rollout, and the Supreme Court would come last in the courts of the state in terms of implementing electronic filing. So what you see now is rules that were sent out in anticipation of a late August implementation. They require, as did the trial court ones, a notice period so that everybody is on notice that this is coming, and so that there's opportunities to get ready with instructions for folks about how to do it, and training opportunities with respect to that. So the anticipation here is that they're out for comment, the comment period will end, and then there will be a time in which two committees, and this is where the procedure is a little bit different because of the overlap of responsibility in the rules you're seeing and in the nature of the rules. Two committees will look at the comments that come in. Those are the Electronic Filing Rules Committee, which I'm chair of, and the Civil Rules Committee, which Alan Keyes, if he didn't escape, is chair of. I think he did, which has traditionally had jurisdiction over changes in the rules of appellate procedure. That is the rules governing procedures in Supreme Court proceedings, particularly appellate ones. This had a little bit different genesis from the original rules of electronic filing. I created a special subcommittee of appellate practitioners. Vermont is not a state, given its size, that has a lot of full-time appellate practitioners, but it has some that do a substantial portion of the appellate work in the Supreme Court. And it happens that I was able to get somebody from each of the standing rules committees to be on this special subcommittee, including, by the way, Alan Keyes from the Civil Rules Committee, who's done many appeals from private practice, in order to go through the process of looking at the changes that are necessary for electronic filing and anything else that might need or should get changed at this time that we're doing the electronic filing rules. And so this subcommittee met 5 or 6 times, as I recall. It reported back to the both the Rules of Electronic Filing Committee and to the Civil Rules Committee. Both recommended that the proposal go out for comment. And that's where we currently are. There have been, I will tell you, since they've gone out, 1 comment, and I'll tell you what it is in just a minute. There haven't been a lot so far of comments. This is not surprising because in general, this is following the procedures that had already been created by the rules of electronic filing for the trial courts. As much as possible, we're using the same process and procedures. There had to be a few changes, and I'll talk about those in a minute. So I'm not surprised that we haven't had a lot of comments. And I'm also not surprised because this was a very strong drafting committee that I think did a very good and thorough job. And that was shown when the master committees who went through the proposal to it and really wanted almost no changes in it, that it was generally a good job. So let us give you a little summary. The way we're gonna do it is that I'm gonna give you a little summary of amendments to the Vermont Rules of Electronic Filing. That is the ones that were created for the trial courts to now make them applicable to the Supreme Court. And Emily Weatherall is going to talk about amendments to the Rules of Appellate Procedure. And then Judge Morris is going to talk about the one amendment that has occurred to the Rules of Electronic Filing that's already been promulgated, but we hadn't had a chance to talk with you about it. So we just want to inform you as to what happened to it. And I think about that particularly because there has been, I certainly have observed it in the meetings of this committee, some controversy over the implementation of electronic filing in the trial courts, despite widespread support for it. There's a lot of details in this, of course, to do, and there was varying points of view about some of them over time as they came up through the process. I want you to know about one thing that got fixed, and that's what Judge Morris is going to talk about, because there was an issue that needed that. So unless there's any questions about the overall approach to this and what's been going on in the procedure, I'll launch into talking to you about the rules changes.
I don't see any hands, so please continue.
Okay.
Take it back. Senator Clarkson's hands up.
So thank you, John. I wasn't going to address the implementation until you were done, but I do. Maybe the rules have been stronger than the implementation, although, you know, one of the things I'd really appreciate is an update on the implementation, because it had a very rocky launch, and I know it's now gone almost everywhere. And if you're willing to embrace them at the Supreme Court, or the Supreme Court is willing to, the implementation must have improved. So I'd really appreciate an update and fit it in whenever, and if Judge Morris is going to do that, we'll look forward, but I just want to make sure we have that update on the implementation.
Okay, I can make a couple of comments, but of course I wasn't the implementer. So these are observer comments, probably just like Senator Clarkson's comment about what she observed from being here, although I did get much more involved in it as a result of some of the issues that arose. There had not been training on the rules part of it. And the rules, the purpose of the rules is to take the requirements that are imposed by virtue of having this software from this particular vendor, translating them into how practitioners have to use them, and thus getting a set of that how you use them rules to do. There are also, of course, instructional materials on the software itself, how it works and what it does. And all of us, including the people in the Rules Committee, needed extensive training on that. In fact, one of the problems that we had going into it was that it was hard to find out all the information needed to do the rules because there wasn't a good place and thorough.
Sorry about that. I hit something wrong and I was trying to get rid of the chat here. Sorry about, continue, Justice Dooley, sorry.
Okay, somebody has to press the continue button, I think, here.
No, I think you're good.
Okay.
I did.
I pressed it. I don't know why it allowed me to do it, but I did. So recording is continued.
All right.
Maybe it's governed by the same software concerns that we're talking about.
Right.
So anyway, we did have, and it was clear that it would be helpful if there were some more training between the rollouts, and we did have some that I participated in. Judge Morris participated, Emily Weatherall participated, and members of the committee did. Some was sponsored by the judiciary, some was sponsored by the Vermont Bar Association, and so the VBA at its midwinter meeting had 3 or 4 events that occurred on the training. Again, we all participated in some of that. Other members of the Electronic Filing Rules Committee participated in other of the activities. I think from our perspective, that helped a lot. I was concerned about, as we went along in the rules, the communications, both with the people who I had observed from coming to this committee were dissatisfied or otherwise, and tried to create active communication channels that would give us much more information about what was happening both internally and externally. And I think that has helped considerably to do it. And let me just say about these things, I've been involved in a number of technology implementations in my life, some in the court, some outside, is that there's a certain amount of controversy that comes with technology implementation that is, if not unavoidable, difficult to avoid. So you see, as bugs get worked out, more communication occurs, and the rollout goes from one place to the next, rather than trying to bring everybody in at once. Situations improve. So I think at this point in time, we are generally in good shape. I see Terry Corsones is on. She's also a member of the Electronic Filing Rules Committee, and that's been an important communication link for purposes of the rules. She being the director of the Vermont Bar Association, and being a conduit for communication from members of the Bar Association to the committee and to the judiciary generally. I think in general that things have gone along in this part of the world in a good direction, and that we are in reasonably good shape. If you want the external view, then I encourage you, Terry, to give her reaction to this. Let me say about this particular rules that we're talking about, we asked for a VBA representative on this drafting subcommittee because we wanted them to be active participants from day one in this set of rules. And Terry appointed a particularly strong member from their section on appellate practice. And I think that was very important to this process going forward relatively smoothly. So that's, I think, as much as I can answer, but if you have more of a question, Senator Clarkson, I'll try.
Terry, did you want to weigh in in response to Senator Clarkson's question?
Sure, if the committee would like, and thank you, Justice Julie, for making mention. In very brief summary, and I wasn't anticipating testifying, but in brief summary, the training materials definitely have improved. Since the beginning, there weren't Vermont-specific training materials, and those have been developed, which has been a big help. In addition, the court users group that was convened to meet with Doug Rowe as a result of Act 120 was able to highlight a number of the issues and prioritize them, and there have been some modifications that have been very helpful, making the file and serve the default, for example. Also developing a mechanism for emergency filings, because there still is a delay in processing and emergency filings were somewhat in limbo. Now there is a mechanism. The court users group has actually been recently reinstated, and we've been asked that they serve as a liaison with the new Standard Practices Committee that also came out of Act 120. We have been waiting for some time to learn what the logistics would be for that interaction. But recently, actually just this past week, the group met to develop prioritizations that we're passing on in the hopes that the Standard Practices Committee will then develop a way for results to happen. So the current situation is we do have the court users group, which represents a variety of dockets and practice areas around the state. Will serve as a liaison with the Standard Practices Committee, which I guess is in the process of still developing. So they're are a multitude of kind of issues, as you can imagine, to address. But we're hopeful that this means of communication will result in continued modifications and improvements. And it's also a way for court users to, we have an info@vtbar.org email chain so that information can come in and we can ideally categorize it and prioritize it in the hopes that we can help, continually improve the Odyssey system. Actually, Senator Benning is probably a good person to check and ask how things are going since he's an active court user.
Senator
Is
Benny.
this where I jump in and complain?
Yes.
Well,
I will only say that the training materials have certainly become much more helpful. I have one remaining issue, and I shouldn't say that. There are impractical circumstances in various cases that make this filing system extremely difficult. And I'll use one example. A client who has 12 separate dockets filing plea agreements across the board in all of those dockets. When you literally have to file a plea agreement for each and every one of those dockets, you are now talking about an hour's long experience trying to just get the documents filed. That will go away as people become more used to having the filing system work. But I have one remaining specific complaint that I do hope your committee will work on, and that is the case number itself. Current docket numbers have three advantages. One is you can tell what year a case was filed. Secondly, you can tell what month the case was filed. And finally, what court the case was filed in. The new case numbers only enable you to discover what year the document was filed or the case was filed. So we've lost the ability to walk into, say, a jury drawing situation, various attorneys, and know whose cases are older than who others' cases who may be in the process of doing a jury draw. We have some sense on who's going to end up going first. That's lost. When I can't figure out what case number is attached to which county of an individual I represent somebody in, and I represent people in 4 counties primarily, that's very difficult. I don't know who the prosecutor is. I can't tell by looking at the docket number anymore. So my specific request is, if there is a way for this committee to be able to convince Tyler Technologies to change that and to incorporate some kind of a case numbering system where the county and the month, as well as the year, can all be identified, that would be most helpful at this stage. Thanks for the opportunity, Tara.
well, thank you. We will add that the point about filing a pleading across multiple dockets, that is already high on the priority list that we're hoping can be addressed. I should also thank Justice Dooley and the Vermont Rules of Electronic Filing Committee for making the amendments that have been made. Those were helpful, very helpful in clarifying the whole service contact and public list contact issues that were very problematic early on, and we're working to resolve those thanks to the amendments.
Thank you.
And thank you for the comment, Senator Benning. I think I got it from this, so I don't think you need to put it in writing. I don't think I need to ask you to put it in writing. I think I get exactly what the issue is. And so we have a meeting coming up and we will start looking at that. You particularly understand the issue, I can tell from your last sentence, which is some things are imposed by Tyler, and as much as we want to change them, we can't do it. If we can change them, then we are absolutely want that kind of suggestion to go to work at it. So we'll see what we can do. I don't know off the top of my head about this. When I said communication has improved, we have now links to answer questions like this, which we didn't have in the beginning. What's changeable, what's not, what amendments you can do. And now we can get direct communication on answers of those exact questions, and we'll get on it right away. Thank you.
Thank you. Thank you.
Let me go into the rules so we don't get too far behind. As I say, I'm going to do the changes in the rules for electronic filing. When we did them originally, we did them only for the trial courts, but we knew that there wasn't going to be a lot of changes for the Supreme Court, and that we wanted procedures that would function for all the judicial entities. So what you've got is amendments to 6 of the rules. The first one is exactly in Rule 1 as it was for the trial courts, giving the procedure for introduction and what cases does it apply to. So the rule amendment, it says there's got to be a 30-day notice of the introduction of electronic filing by order of the Supreme Court, with the date specified, that it will apply to all cases, including those currently existing. That is, after the 30-day period on the go live date, there will be required electronic filing, even in pre-existing cases that are partially on paper and partially electronic. Of course, because you're talking largely about appeals, but that's not the only jurisdiction of the Supreme Court. There are some original proceedings, not many, but there are some. You're talking about appeals. These came from the trial courts mostly, not entirely all either of that. Then electronic filing having occurred earlier in the trial courts, most of them will be a fully electronic record, but there will always be a few that go back to the paper days to do. So that's Rule 1. I'm just going to, if it's okay with the chair, I'm just going to keep going rule by rule by rule. And if I see a raised hand, I will stop. And otherwise, I'll just keep going. Is that okay?
That sounds good. I'll also watch for raised hands. So.
Okay. All right. Rule 3 is who's required to file. What are the requirements, and when do these requirements apply? Again, the Supreme Court proposal is to take the same rule as from the trial courts, and of course, in broad swipes, this means lawyers are required to e-file. Self-represented litigants are not, but can if they so desire. There's a little change for the Supreme Court in a self-represented litigant stopping e-filing. You'll see that in D3 of Rule 3. There is a presumption that they will continue on appeal in the Supreme Court. And if they want to discontinue, they have to give notice of that. They don't require court approval, which is required as to the Superior Court. But if they don't give any notice, they are required to continue e-filing to do it. This is mostly so people are on notice of what the rules are. The issue is, of course, if a self-represented litigant wants to go back to paper, everybody knows they have to serve them and give them notice of things by paper, and use of the mails or delivery service or whatever. So they need to know that that's occurring. So thus action from the self-represented litigant to do it is needed. So that's the amendment to Rule 3. Otherwise, Rule 3 from the trial courts applies as it is. Rule 5, procedures for electronic filing. This probably is the more substantial change, and even it's not a major change from the trial court. It's in particularly in 5E. Which is separate from it. In general, and you've heard about this software program, in general that people file, but it goes to a clerk review process. The clerk decides whether it's a compliant filing and notifies you, yes, it's okay and it's accepted, or no, it's not, and you need to correct it, and gives you time to correct it. That's the way the system is put together. It also is in here the same system in when it's non-electronic filing. And the rejection can be for any violation of the rules. of which there are a number of possibilities. The Supreme Court's tendency has been, it's kind of a cultural thing over the years, not to reject filings because of non-compliance, instead to accept the filing and then deal with it later as to the non-compliance if it wants to do something, and sometimes it doesn't. So it's more limited in the grounds for rejection. There are essentially three. One that has to be, which is that it'll be a public access failure and private information will be disclosed if the filing is allowed to go forward publicly. And that's a cross-reference, and it's the same in the trial court, cross-reference to the rules of public access, Rule 7A. Two is that with respect to briefs, the word count limit is been violated, or there's no indication what the number of words are, and you can't tell whether the word count has been violated. And third is that something's not signed, and therefore it's not formally presented in proper form. Those are the only three grounds for rejection in the Supreme Court. And again, you have the same opportunity to correct in the Supreme Court as you have in the trial court, essentially a week to do that and get in a compliant filing. Also, there's a scale down, as there had been, and this is also in the rules of appellate procedure. I think Emily may touch on it. Requirement as to how you assemble things for purposes of filing them. You have to file separately. You can file together alternative forms of relief, but independent forms, different things entirely. You have to make separate motions for those. This is about motions. And you can't combine a motion response with a new motion or a new request for action to do it. The trial court rules are actually more complicated than that. You can see them in the pre-existing version of this rule. I'm still on 5, so we're talking about 5, what is now 5G. And that part is not, the more complicated requirements aren't adopted for the Supreme Court. Again, it's more informal in its culture and history. Same rules for non-electronic filing are in Rule 6. So that's applying the same requirements that I just talked about for requirements that come in on paper for people who aren't required to electronic file and don't. The one comment has come in as to Rule 7 on formatting. And a requirement that was left out, frankly, earlier and is now put in, that is required by the system, not by human interaction, is you can't use a hyperlink or internal bookmark that is live. That caused the one comment that's come in from Judge Tour said, why not? I want those things. What does she want? She wants citations to cases and statutes to be live, so she just has to click on them on the electronic document and go right to the case to read what she wants to see, or right to the statute to see what you did and what's applicable on that thing. We now know the system doesn't allow it. If you do it, if you put it on a document, it will be what I call dead. Namely, you can't click on it. You can copy it and use it so that it isn't totally without use, but you can't actually, it isn't live to you as a part of the document that you are seeing. And we had to add that here to be clear that that's that's a system requirement and nothing we can change. So what I believe will go back to Judge Tour is something like, if it comes from me, oh, I would love to have that too, but I'm sorry, I can't do it. The system can't do it. And then finally, there is something about court fees, and I didn't cover this earlier, but it was one of the ones in Rule 3. The Supreme Court because actually I think of a statute, it's in the reporter's note. It does not refuse filings unaccompanied by required filing fees or a request to file in form or papyrus. Whereas in the trial courts, if you don't file any filing fee that would go with it, and this is mostly, of course, a case initiation, but not entirely, you will or don't request in form or papyrus, that is a waiver of fees, that filing will not occur. In the Supreme Court, it will occur. The Supreme Court will say, of course, thereafter, that you didn't do the filing fee, you have to do it, or this case will be dismissed. But that's of course a technical distinction, but that is the current law and practice of it, and it's just adopted here. We have also did the drafting to clearly separate out the e-filing fee, and as I think you know, there is a restoration of e-filing fees differently from what they were originally proposed, and to separate out the e-filing fee from the entry fee for a case applicable whether you e-file or not.
I see Senator Sears has a question.
Yeah.
I guess my question is, there's a contract with Tyler Tech, and if we exempt some people from fees, somebody else is paying that bill. Who is paying that bill?
So the primary situation in which a fee is not being paid, and now I'm talking about entry fees. There's nobody exempt except the people. No, let me take that back. Let me go down the course I was going. So the primary thing is that people who have a waiver and because of financial circumstances aren't able to pay the fee and get to go forward in form of papyrus. Of course, there are also statutory examples of people who don't have to pay a fee. Prosecutors, public defenders, the state as a general actor does not have to pay a fee. Anybody who does not have to pay that fee to the judiciary on filing, which goes into the general fund, that fee, also does not have to pay an e-filing fee, which would have gone to Tyler Technology. So the way you asked your question was, is somebody else paying it? No, it's not being paid at all, is the reality of it. Nobody's paying Tyler Technology that e-filing fee on behalf of those who didn't pay it, and nobody's paying the general fund on behalf of those who didn't pay it. It's just both are absent the money.
Well, I have to assume that Tyler Tech's contract then there's heightened fees for other attorneys and other litigants who are paying fees.
Yeah, you're beyond, and I understand your comment that they want a certain amount of money and they want to, if they can't get it from X, they'll get it from the rest of the people. I understand that, but I'm not part of this negotiation. This is not
I understand,
something
Justice.
that I had anything to do with, so I don't know the answer to your question. I was almost, Terry, who knows it a lot more than I do, might have a different, might have a comment on it, but I've gone as far as my knowledge is.
Thank you, Justice.
Yeah.
Terry, do you want to comment on that?
Well, I think just as a practical matter, the litigants in the civil, family, and probate dockets who are typically not exempt the same way as in the criminal docket, as Justice Julie indicated, but, you know, there are no criminal filing fees. So it's the other e-filing dockets, civil, family, criminal litigants who are not able to waive the fees, who are basically paying the e-filing fees.
But
Yeah,
are those
the question-
fees higher as a result of exempting others? In other words, the state is exempt from paying a fee, as are the public defenders, the state's attorneys, the court itself. So if all those are exempt from paying the fee, one has to assume the contract took that into consideration And there is more of a fee to the litigants who are paying a fee than there would have been otherwise. That's my only point. And it's one that I think as we talk about who's exempt, we have to realize. But there's also a cost. Senator Benning was telling me it took him 3 hours to do what used to take him an hour to do with the new electronic filing. So there's a cost there. Either he's eating that cost or is whoever he's charging is taking the cost too. This is, I obviously have my concerns about the e-filing. It's this probably is not the proper venue for that, but I just do have to push back a little bit when we talk about exempting people and they're not paying a fee.
Thank you, Senator. I would assume the same as you. We weren't involved with the negotiations. The contract is up for renegotiation in June of 2022. And ideally, these kinds of issues can be included. And now the e-filing fees are subject to the e-filing fee report given to the legislature every 3 years. So hopefully that will be another, way to address it.
Thank you.
And thank you for the opportunity to do the proposed amendments to the rules of electronic filing. And I'll turn it over to Emily to talk about the rules of appellate procedure that are also proposed to be amended.
Good morning again, everybody. Again, I'm Emily Wetherell. I'm the deputy clerk here at the Supreme Court. I just wanted to mention 2 general things. One might respond a little bit to Senator Clarkson's question about process. And I know Justice Dooley talked a little bit about how when we were looking at doing the rules for the appellate filings, we really did purposefully try to get a large group of people in to be part of that drafting process. But I also wanted to mention that last week on June 8th, the Supreme Court held a bench bar meeting that was noticed to the whole bar. There were probably about 50 people that attended that. It was done remotely. And I also discussed the proposed amendments to the appellate rules and the e-filing rules at that meeting, and requested people to submit comments that they might have to the rules. So, we've really purposefully tried to proactively reach out to the bar and try to get comments before things go live. And in terms of the fee question, I'm sure that the court administrator would be happy to engage with the legislature in another forum that wasn't really on our agenda. So it's not something that I'm prepared to talk about today. But I'm sure that, none of us are sort of the witnesses that were called for today are probably the proper people to be talking about that issue. So if the legislature wants more information about that, we should make sure that there's someone who's here that could properly sort of address that issue. I know the meeting says we're supposed to adjourn at 11:30. So I will try to give an overview of the appellate rules without glossing over too much. There are 27 appellate rules that are proposed to be amended. So what I would like to do, if it's okay with the chair or the committee, I've sort of broken down the amendments into 4 categories. And instead of going through each rule, I'd like to talk about those 4 different categories. And if there are questions, I'm happy to drill down and talk about a particular rule if that's something the committee wants.
I think that's fine.
Okay. So the sort of 4 areas that I've identified that I think are places where we did make proposed amendments to the appellate rules. The first is changes that are directly related to the implementation of e-filing. The second are rule changes that were required because the court is going to move, instead of having a paper case management system that imagines paper files, that we're going to be moving to an electronic case file along with an electronic case management system. The third are some rules that were amended really to conform the rules to current practice and to be really clear about what the standards are. And then the fourth are a few changes that were made regarding public access. So that first sort of group of rules that were amended have to do with the implementation of e-filing at the Supreme Court. Justice Julie already mentioned that we did include definitions to differentiate between an entry fee, which is the fee that you would pay at the initiation of the appellate case, a filing fee, which would be any other court fee, and then the e-filing fee. And we felt like it was really important in certain places to be able to differentiate between those three different kinds of fees. So now there are definitions that very clearly set out what those three kinds of fees are. And then there were, in the rules, there were some places where it was a little bit unclear about when the entry fee was due and where it should be paid. Just so the committee understands, most of the cases that the Supreme Court handles are appeals from trial court proceedings. And in general, when there's an appeal that's filed, it's filed into the existing Superior Court case. And then that appeal is transmitted to the court, and the court initiates the case being opened here at the Supreme Court. And so most of the entry fee, the fee to initiate the case, is paid into the Superior Court case. There are a couple of different weird situations, appeals by permission, federal question, appeals from agencies, where that's not the case, where the fee would then be paid directly into the Supreme Court case. So we wanted to be really clear in the rules about when that entry fee was due and how it would be paid. There was a little bit of a talk earlier. I think Terry Corsones was talking about some of the amendments that were made to the e-filing rules recently regarding service and certifying service. The existing rules at the Supreme Court about how you certify service were different than in the Superior Court. So in the Superior Court, you have to file a certificate of service. Or if you're e-filing, the way that you certify service is through a submission agreement. And we wanted to make sure that how you certify service at the Supreme Court is the same process that you would use in the Superior Court, because it's the same e-filing system. So we can't have two different sets of rules that apply. So in Rule 25, there are some changes there regarding service and certifying service. And Justice Julie mentioned this a little bit when he was talking about the e-filing rules. There's some back and forth between the appellate rules and the e-filing rules. So regarding the formatting for documents at the Supreme Court, I'm not sure if you realize, but when an appeal comes here, there's a brief that's filed, and that brief can be quite large. And then there's also all of the documents that are coming in from the trial court. And in our paper world, what you were filing was a piece of paper, and what the court was reading was a piece of paper. And we had some very detailed requirements in Rule 32 about how those documents should be formatted. Well, now what's being filed is an electronic document, and what the court is reading is an electronic document. And so we needed to relook at all of the formatting requirements, both in Rule 27 pertaining to motions and in Rule 32 about briefs, because it's different kinds of requirements that make for easier reading of an electronic document versus a paper document. And a lot of the amendments that we put in Rule 32 came from a white paper that was written by the American Bar Association that made a lot of suggestions about what are the best formatting requirements for reading an electronic document. And the committee discussed that at length. Justice Julie mentioned that one of the requirements there is that there aren't live links that are in briefs or internal bookmarks because of the requirements of the e-filing system. Some other states that have e-filing and have that same limitation on the things that are coming in, they require two sets of briefs to be filed. So one into the e-filing system without any of those links, and a separate one to an email address that would have those links. And we discussed that with the subcommittee, and the attorneys that were on that committee felt like in the beginning that would be a burden on attorneys to have to file two different sets of briefs, to have one with live links versus, so, you know, that's something that we might continue to look at, but for the moment, we decided that that wasn't something we wanted to implement right away. So those are sort of the overview of changes that were directly related to the fact that documents would now be submitted by e-filing. And I should say that we do have self-represented litigants at the Supreme Court who are not required to e-file. So there are provisions in the rules that are left in there related to non-electronic filing. But all of those documents that are coming in on paper, they will be scanned in just like in the trial court and become part of the electronic case file. So in terms of having an electronic case file instead of a paper file and using a new case management system, we also needed to make some changes to the rules related to that. When we get an appeal at the Supreme Court, it's important that we be able to see the whole record of what happened in the trial court. And previously we received that paper file from the trial court, but litigants were also able to file what was called a printed case to provide the court with the main documents that were relevant to the appeal. And so there were some major changes that needed to be made to the rule on the printed case, which is Rule 30, because now that there's the electronic case management system in the trial courts, we can create what's called an appeal volume that contains all of the documents that were electronically filed into the Superior Court case. And that's something that we can just do internally. It has a table of contents, and then the litigants in the case can cite directly to that appeal volume without having to file a printed case. The attorneys that were on the subcommittee really wanted the ability to be able to have the option of filing a printed case, even where it was not required. And so that was something that we implemented into the rules, were not requiring the printed case when there was an electronic case file from the Superior Court and you had an appeal volume, but allowing attorneys to continue to file a printed case if they chose to in their particular situation. We had to make some changes in the lexicon that we've used in the past. So in lots of instances in the appellate rules, it talked about a paper being filed. We used language like document instead of paper. The rules also often referred to an original. And when you're talking about electronic case management, an original doesn't really mean very much. So we had to talk about an official copy instead of an original. We also removed all of the requirements in the rules to file multiple copies of things. It used to be under the rules that you had to file 8 paper copies of your brief and your printed case. And I'm sure lots of legal assistants are going to be happy to know that they no longer have to compile 8 copies of things that they're filing with the Supreme Court. It's just that if you're an attorney and you're a mandatory e-filer, you're going to e-file the electronic copy, and that's it. There's no paper filing that's required. And yeah, sorry, go ahead.
So the printed case, is that just a term of art because it's actually filed electronically? And is that confusing?
Yeah, it is a little bit of a, so that's what traditionally some other courts call it, an appendix or the record on appeal. Different appellate courts have different names for it. Traditionally, it's been called the printed case. And we did discuss whether to change that name, to your point, Representative Lalonde. And the members of the committee felt like because in the appellate community in Vermont, the term printed case is so well known as to what that means, that for the moment people wanted to keep that name. There are a small group of cases where the printed case still needs to be filed, and that's mainly appeals that we get from administrative agencies, executive branch administrative agencies, where there isn't e-filing and we can't create that appeal volume. But for the most part, appeals that are being brought from Superior Court, there is no requirement anymore to file that printed case. We'll just create that electronic appeal volume, and that will be the record that people cite to in their briefs. And so we did add a definition into the rules on what is an appeal volume, so that that's a little bit more clear to people. And there are particular examples in there about how to cite to the record on appeal, how to cite to the appeal volume, how to cite to the printed case. And there's a rule that we needed to amend regarding the custodian of the records. The rules for public access to court records contains a provision in there stating that the court administrator is the records custodian for all electronic case records. So we needed to update the appellate rules to provide for that same cross-reference. As we were going through the rules, we tried there. When you haven't gone through rules for a long time, you always find things that you think, oh, why did we write that way? That should be updated, or that's, we should really change that rule. And we did try not to make a lot of those kinds of changes to focus on what the job was, which was to update the appellate rules so we could implement e-filing and electronic case management. But there were a few rules that the committee felt like it was really important to clarify some of the process so that we could get, as we're configuring the e-filing and Odyssey, so we could configure it properly to conform to current practice. So some of the rules that have some pretty big changes in them related to that conformance are rules 5, 5.1, and 6. And those are all rules that are appeals before a final judgment. So this would be a situation where you wouldn't have a final decision in a case, but there's some interim decision and one of the parties is asking the Supreme Court to review that interim decision before the final judgment. And or Rule 6, which are appeals by permission to the Supreme Court. So that would be a small claims decision that was appealed to the civil division, and then to the Supreme Court is an appeal by permission. There was some inconsistencies between those three rules as to where you file certain requests for permission and when the fee is due for those rules. And so some of the practitioners that were on that subcommittee worked with me to update those rules so we could get some clarity and some conformance across those three rules. The rules also at the moment continue to refer to cases where the record is a video recorded proceeding. This is old technology that was used in the trial courts in Vermont. Instead of creating an audio record of a proceeding, there was equipment that created a video and audio record of the proceeding. That technology hasn't been used for, I think, 6 or 7 years now. And so those rules are just really outdated, and we took the opportunity to take those provisions out. That's primarily in Rule 10 and Rule 12. And then there's a rule that allows attorneys to stipulate for extensions of time for the filing of a principal appellant's brief, an appellee's brief. And again, the attorneys that were on the committee feel like the rule was really unclear about what could be, what kind of stipulation could be filed. And it also did not address the reply brief. So in Rule 26, we did update that to make it really clear about when a stipulation can be filed and for how long of an extension of time. And then Rule 28, which delineates the different types of briefs that can be filed in a case, including those when there's a cross appeal. Again, there was some attorney members, including Alan Keyes, who was on this call earlier, who suggested that we clarify that rule and make it more in conformance with the federal rule. So we took the opportunity to make some changes there so that we could be a little bit clearer about when briefs could be filed and what should be filed, what should be addressed in each of those different kinds of briefs. My last group is rules related to public access. And so I just want to pause for a minute and make sure that there aren't any questions about all of the three categories that I've already sort of laid out. Okay. And Justice Julie, I can give a little overview, but if you prefer to, do you want to talk about the three sort of public access changes, or do you want me to give them an overview and you can answer questions?
Yeah, just very quickly on public access, the basic public access rule is, of course, that information that is private under the statutes and rules of public access are not to be filed, or that whatever is filed has to be redacted of the information involved that is private ahead of time. First and foremost, these rules say that applies in the Supreme Court too, for any original document you're doing there, but you don't have to redo it for information that was filed in the trial court, because of that, of course, went through clerk review and public access consideration and the requirements when it was filed in the trial court and when that would remain in the Supreme Court. So that's essentially the underlying system. One thing that's been the rule in the Supreme Court for as long as I've known, but has never been specified, is included with respect to oral arguments, and that is that oral arguments in cases that are non-public, let's say it's a juvenile case, are conducted in open court, but the lawyers and parties, whoever the advocate is, must address the participants in the proceeding by initial and not by name, so that they aren't named for that process. The briefs are not public. Again, that has been the rule, but the argument is, and so this now specifies that rule, that you can't, if you're an advocate, refer to any of the participants in a non-public proceeding by name to do it. Those are the main ones. Of course, as Emily said, one of the challenges is going to be with the appeals from the administrative agencies. They have not had a review for public access purposes. Some of them have their own privacy requirements, particularly the Human Services Board, which is one of the administrative agencies that has direct appeal to the Supreme Court and is a source of a significant number of cases to do. The rest of them can have private information, and so there has to be some way that they are screened to be sure that the non-public information doesn't get into the record and be available electronically for public access. So this rule imposes that on the administrative agency for which they came. They must be sure that when that record is delivered to the Supreme Court, it complies with the rules of public access with respect to privacy protection. And that's the kind of third area I think Emily was referring to about this. Did I miss one, Emily? I can't remember. I think those are basically it.
Yeah, the three I had were just the clerk review for public access at the Supreme Court, which is the same as the requirement at the trial court, and that you'd already touched on as to the e-filing rules, and then the rule regarding the public access for agency files, and then the oral argument rule. Yeah.
Okay, so is there a question? Did I see Senator Clarkson's hand go up? Yes.
Yes, Senator Clarkson.
Thank you all. It's great work. I guess what's running through my head as I listen to all of this shifting electronically is cybersecurity. Our documents are now subject to ransomware, to cyber attack. I'm not at this point, because I know we're after our hour, the witching hour when we were supposed to adjourn, and I want to respect people's time. But I think it's an issue that we ought to be addressing, and I assume you are addressing. But we now make ourselves far more vulnerable. And when we talk about not having originals, I really worry. It's like, well, what happens if we're hacked and it all is taken down? And what happens to all those cases? And how are we making sure that things will be protected? So I think at our next meeting, I'd really appreciate an update on what we're doing to protect ourselves now that we are shifting so completely to the electronic world.
Okay. We wouldn't have been the ones who could have done it in the detail you need and deserve in any event. So we can take back to the judiciary that we can have somebody on next time who is the specialist in exactly that subject and can address it.
Well, and thank you, Justice Julie. I guess there may be appropriate rules that you are considering to be proposed around what individual actors within the system can do to also protect. So there may be, and you may have contemplated these already, but it's incumbent not just upon, I mean, the concerns are on the outside, but they're also on the inside, and rules we can enact to protect ourselves and make us less vulnerable.
Okay. Okay, thank you. And I'm going to turn it over briefly to Judge Morris to describe the amendment that had occurred. And I know we're really at the end of time, so this will have to be very brief.
Let's try 2
But
minutes.
he's used to doing things very briefly.
So let's try 2 minutes here. First, on the package that you've just heard about, the comment period closes July 2nd. We've done a lot of advanced work with a special subcommittee from both civil rules and electronic filing last week to very carefully review a final proposal. And I would imagine the court, certainly the recommendation is the court act promptly to promulgate this package in time for summer implementation. You should note the electronic filing rules that these amendments will still apply to require a 30-day advance notice of the commencement of the new e-filing and case management system in the Supreme Court to the bar, and opportunity for training and information about that. So whenever the court acts to promulgate, the bar will have 30 days before it's live. I just want to talk quickly about the amendments to electronic rules 2, 4, and 11. It goes back to that time that Senator Clarkson was talking about in December, January, when Odyssey had rolled out into the Western units, Bennington, Rutland, Addison, Chittenden, the bigger volume courts, and there were major issues with service via the e-filing system, Odyssey. And this came from a kind of a lack of training and misunderstanding, but also a kind of a lack of clarity as to the process. So 2, 4, and 11 were amended on an emergency basis, I should point out. They were emergency rules on February 22nd, effective March 15th, which was when the last group of courts went to e-filing. 2 added definitions of the key term service contact and submission agreement. The confusion over service contact was that lawyers seeking to serve people via Odyssey were just using various email addresses, not the ones that the other parties had registered as the ones for which they would receive service in Odyssey at. So those definitions clarify that. Rule 4 is really a procedural manual statement within a rule that says, here's how you create a service contact, a public service contact, and you must click, that's what the rule says, you must click public service contact when you register for e-filing. So that's what that did. It was helpful, but it's in a rule. And Rule 11 amendments dealt with clarification of service electronically. Just briefly, 3 ways of serving people now with the world of Odyssey. If all the parties are e-filers, remember all lawyers have to be e-filers. So in that world of mandatory e-filers, it's simple. When you serve on the page, you come to a submission agreement box that has 2 little paragraphs with 2 little checkboxes in it. One is, I certify I've complied with the rules of public access for protection of non-public information and sorting it out, basically. Number 2 is saying, I have served all parties who are mandatory e-filers by hitting Odyssey file and serve. That's the thing, file and serve, which triggers service to those people at their registered email addresses. Or I'm not required to serve because I'm a prosecutor and I'm filing a ex parte motion for a search warrant, or I'm a litigant filing an ex parte motion for replevin or attachment or the like. That's authorized by law. You don't have to serve. 3, I've served Odyssey e-filers by file and serve, or I've filed in compliance with the civil rules, everybody else. So in other words, the old ways of service still apply. If you have a self-representer who's not required to engage in e-filing and e-service, and you have to, in that event, default to the civil rules, and you have to file a written certificate of service along with your documents when you're entering your case. That submission agreement checkbox is the gatekeeper. If you don't check those certifications, you can't complete your filing to begin with. So it's all to clarify and simplify service. One thing that was retained under the civil rule Parties could agree to alternate methods of service, including lawyers. The requirements for that are spelled out, and they're frankly onerous. Basically, they tend to suggest that as a lawyer, I don't want to engage in alternative service. I want to file through file and serve by checking the box. If you as a lawyer agree with another lawyer to do alternative service, say by email, you have to file that agreement electronically with the system, and you have to have email addresses at which you're going to be filing them, and you have to use certificates of service filed in each instance of service as well. So for obvious reasons, the lawyers would say, I'm going to use Odyssey File and Serve by clicking the submission agreement, but they still have that ability to opt out if they choose. And I think I've just covered those things. This was at a time when, as has been said, there was a lot of confusion. It was really before we had engaged in some significant training for the bar and reception of feedback from them about what needed to be changed. So these were in response to comments that we got from the bar and the users. It was on a fast track. They were promulgated as emergency. And frankly, I don't know where that leaves it with your committee's review. I'm assuming that you still have a voice with regard to that promulgation. That's what happened there.
So I appreciate that, and I'll defer to Eric as far as whether we need to look at it next time we meet. Any questions on that, folks? I don't see any questions. I just wanted to flag one thing really quick because I know that we're a little bit over, but on Rule 10, page 19 and 20, the use of the informa pauperis language. I know that elsewhere in various rules that we've looked at today, we've been changing to language along the lines of waiver of filing fee and service costs. And if you could just perhaps take a look at that to see if that's language that should be changed or not to be consistent with apparently the way we are moving to more English and less Latin. So any other questions from anybody else? I really appreciate everybody's time. Sorry that it went a little bit longer. I'll take the blame for that as well. I'm not gonna blame my fellow South Burlingtonian Justice Dooley at all.
It's not an issue of blame.